Good morning, Mr. Afiq. How are you today?
Good morning. I'm fine. Can you brief me into this client?
Oh, yes. For today, we have only one appointment, which is from Zailat Sendian Berhad, which is Mr. Lee. So I have a conversation with him last yesterday, and they're seeking for our legal advice into the next necessary step that should be taken.
Can I ask what time he will arrive?
Oh, yeah. He will arrive at 11:30 a.m. and Mr. Yuta also will join you as he is available during that time.
Okay, great. Thank you.
Hello, is this Alif and Co. law firm?
Oh, yes. May I know what's your name, sir?
My name is Mr. Lee. I made a call yesterday regarding my consultation.
Oh, yes. Mr. Lee from Xylot India Berhad, right? So, it's a pleasure having you here. Both Mr. Yuta and Mr. Afiq is already waiting for you. Allow me to assign you to a breakout room.
Hello, good morning, Mr. Lee. Welcome to Elephant Co. I am Mr. Afik, and this my partner is Mr. Yutas. We are so glad to have you with us.
Hello, good morning, all of you. Just to introduce myself, my name is Mr. Lee.
Okay, Mr. Lee. Before I start, I would just like to briefly discuss the fees. The first consultation is free, but if you were to consult with us again, the rate will be 100 per hour. Is that okay with you? Uh, and one more thing that I would like to highlight, Mr. Lee, is this session will be private and confidential. In fact, we will not disclose any of the information without your consent.
Okay, just proceed.
So, without further ado, I think we can start.
Okay, so basically to start off with, my company Zilog has a three-story shop based in Sri Kembangan in 2020. And I've been informed by Mr. who is the tenant manager of the adjoining shop house. He said to me that the state government of Selangor want to acquire the three shop office. The state government of Selangor want to develop that area by building the MRT line to project. And then Mr. Ho showed me the Form E that his company received in regards to the acquisition of that shop house.
Can I get a copy of Form E that was sent to Mr. Ho?
Yeah, sure. I brought it with me. Have a look at it.
Okay, so based on this, we can see that the state government has actually explained the acquisition process.
Okay. Is it allowed for the state government to take my property just like that?
Yes,
Actually, they can. Yeah, you can continue, Mr. Afik. Sorry for interrupting.
Sorry. There are a lot under Section 40A, and also based on, but they have to require have a cross check with Section 3 Land Acquisition Act.
Okay. So, but I would just like to ask if there any way we could find any loophole, because I don't want to my property to be taken away just like that.
Yes, there is loophole definitely, Mr. Lee, in which we can argue on behalf of procedures whether the procedures are aligned with what land acquisition says.
Ah, I see. Okay, so how do we obtain that kind of information?
For that, we have to check with the land office first, sir, on whether the requirements are complied with by the state authority.
Okay, please do it soon as possible. Yeah, we need to confirmation to tell other directors insured as well.
Definitely we'll do it as soon as possible, but I would like just to summarize what has been said by you. So based on the discussion, we can see that your issue was you had a property which is a three-story shop office in Sri Kembangan, in which the State Authority of Selangor wants to make an acquisition of the land for MR2 line project. Form E was also served to the tenant manager, Mr. O. Am I right? Did I miss any information?
I think that's really all the information that I could gather.
All right, Mr. Lee, so we'll do our best to resolve this issue. In the meantime, please stay calm, as usually the state authority often leaves loophole in which we can use it for our case, and we'll find that loophole as soon as possible.
Okay, sure.
Will do, Mr. Lee, and this is our business card. So our receptionist will book the next appointment, yeah?
Okay, thank you.
Thank you, Mr. Lee.
Hello, Mr. Lee.
Yeah, hello.
Hello. Okay. Thank you for coming to the office as per requested for yesterday during the call.
Yes, please tell me there is an update with my case.
Okay. Oh, yeah. There definitely is. But first, I will explain. But that will be explained by the lawyers later. Okay. And then I would just like to remind that since it's the second consultation, which means that you have to pay a fee of 100 ringgit. Is it okay for you?
Yeah, okay, whatever. I will pay just talk to the lawyers.
Okay, then allow me to assign you to a breakout room, okay?
Okay.
So hello, Mr. Lee. I would like to share some updates regarding the search that we have made at the land office. So basically, there are a few things that we have found, which is the first thing first is Form A was never issued. Background information: these are requirements in basis of forms where state authority has to imply. The first form is Form A, it was never issued. Form D was also lapsed. Xylox has never received Form B and Form E, and it was only received to Mr. Ho. And Form K was not endorsed.
Okay, got it. So from my end, I would like to ask a few questions and I will make it a brief, okay? Firstly, could state authority simply acquire our property without informing us? And secondly, what we can do with the failure if the requirement that you mentioned just now. And third is if the compensation is not enough, could Xylo object to it? And lastly, is we have signed a sale and purchase agreement with the third party. So what would happen to the agreement? So that will be all from me. Thank you.
All right, I'll take into account all of your questions, but I can't give any detailed any answers as I would like to discuss with my partner. But rest assured that based on the information that we have obtained, we are definitely in good hands due to the failure of the state authority to follow specified requirements under Land Acquisition Act.
All right, thank you so much. So this is something that I can bring to the board and shareholders.
All right, our receptionist will contact you for the next appointment, Mr. Lee. Thank you.
Okay, see you. Thank you.
Uh, so Mr. Yu, what do you think by our clients just now?
So based on the facts given by Mr. Lee, there are four main legal issues that we need to deal with. So the issues are, I'll list them down. Whether the state authority has the power to acquire Xylox land for the state project, whether the state authority has complied with the procedures for acquisition, and if not, can Xylox appeal, and if so, how and on what grounds. And the third issue is whether Xylox may object on the amount of compensation, and if so, how. And the final issue is whether Xylox is liable for to the purchaser for selling the property, notwithstanding the acquisition of the land.
Okay, so let's discuss the first issue, which is whether the state authority has the power to acquire Xylox land for the state project.
Okay, regarding the first issue, the state authority has the power to exercise compulsory acquisition over private property in accordance with Article 13 of our federal constitution, as long as it is done within the boundaries of the law and fair compensation is provided.
Which provision actually stated that under federal constitution?
Okay, that is actually under Article 76(4) of the federal constitution, which empowers parliament to enact laws about compulsory acquisition, and that is to ensure uniformity and consistency.
Besides, in accordance with Section 3 of the Land Acquisition Act 1960, the state authority has discretionary power to exercise compulsory acquisition over private property as prescribed under subsection 31A, 31B, and also 31C of the Act.
That is true. And if we look at the case of Charanjit Lal Chaudhary, the judge in that case said that every sovereign has an inherent right to take an appropriate individual citizens' private property. Sorry for that.
Oh yeah. I remember that case perfectly. Thank you, Mr. Yutas. So does that mean that the government can justify acquiring several properties for Klang Valley MR2 Line 2 project based on the interests of the public?
Actually, even though Article 13 allows for protects private property, but there are exceptions, just like the doctrine of Salus Populi Suprema Lex, which prioritize interests of the public over private interests, and we can also see that in the case of Escola Singham.
So what if the government has a vague purpose in acquiring the land, even though it is for the benefit of the public?
So for that, we need to look at the case of Lian Finance Developments Miriam Berhad against Director of Lands and Mines, in which the government has the authority to determine what constitutes a public purpose, and this is done under Section 3 of Land Acquisition Act 1960.
So does that mean that Mr. Lee cannot question anything or Xylox cannot question anything regarding the compulsory acquisition?
Not really, because the decisions on compulsory acquisition can be argued, can be contested based on grounds under non-compliance, such as non-compliance with the Land Acquisition Act, misconstruing statutory powers, acquisition for inadmissible purposes, failure to consider relevant factors, or bad faith, such as we can see in the case of Sheikh Omar bin Abdul Rahman Taha Al Sagaf and Pemunggut Hasil Tanah, and S. Kulasingam's case.
Therefore, I think we can conclude this issue. It can be said that state authority has the power to exercise compulsory acquisition for private property, but the exercise of this power can be subjected to compliance with the procedure, right?
Yes, so that is very true. And now, what do you think about the second issue, Mr. Afiq? Do you think we can possibly resolve it?
Regarding the second issue, I think the first thing that we should discuss is the Section 41 Land Acquisition Act 1960 that mentions notifications had to be made in Form A, and they must notify the public of their intention for that particular land.
But if we not issue Form A, does that make the acquisition invalid?
Good question, but no, based on good question, but there's two different cases that highlights this. First case is E. Chong Pang against others and others against land administrator of district and of Alu Gajah that mentions even when Form A was not gazetted, it would not affect the proceeding. However, it was overruled in the case of United Allied Empire Sidan Berhad against Pengarah Tanah dan Galian Selangor and others 2018 that mentions non-issuance of Form A would actually invalidate the acquisition.
It's a very good point that you make, Mr. Afiq. Actually, it bears the same liability when it comes to Form D as well, even though it was gazetted, but it has been lapsed. And according to the case of Orchard Circle, where the court quashed Form D and declared all the proceeding as void because Form D had lapsed. So this will be an advantage for our client based on what Mr. Lee said, that Form D had lapsed even though it was gazetted.
So how do we solve the issue regarding Form E actually?
For this, we need to refer to Section 11 of the Land Acquisition Act, where it's mentioned that persons interested must be officially notified under Form F.
Moreover, I would like to add in the case one another that mentions failure to serve Form F will not invalidate the acquisition as it is an administrative step and not provided in the statute.
You're correct, Mr. Afiq. But this won't really help our client because if our client has not received it, it will not make the acquisition invalid.
Last question I would say is on the issue of Form K. Would not having the Form K endorsed, would that benefit our client actually?
Definitely. It was highlighted in section 22(3)(b) of LAA, which mentions that a copy of Form K shall be given to a proper registering authority, and section 23 of LAA that says land administrator will enter a memorial on the registered document of title that the whole land has been acquired.
I would also like to highlight on your point, Mr. Yutas, just now when I was doing my reading earlier. In the case of United Allied Empire Sidan Berhad against Pentadbiran Selangor and others, the position of Section 22 says that Section 22 is actually mandatory as well as the endorsement regarding the issuance of Form K, and that would invalidate the acquisition if it's not properly issued.
Yes, Mr. Afiq. Based on these facts, I think that our client has a strong case regarding the issue that they are facing.
It seems like state authority will proceed with their acquisition. So, on what grounds could our client appeal actually?
We could apply based on non-compliance with the Act through judicial review supported under Order 53, Rule 36 of Rules of Court 2012, but it must be done within 3 months from the date when the ground of application arose or when it was communicated to our client. Moreover, if we look at the case of United Allied Empire against Pengarah Tanah dan Galian, court said that compliance of statutory requirement for land acquisition, which is mandatory, and court quashed the acquisition due to non-compliance of Form A and endorsement of Form K.
So safe to say that our client Zalok Sdn Bhd could actually challenge the acquisition based on failure to issue Form A, Form D as well as Form K by applying it through judicial review. So now can we move on to the third issue, which is whether Xylox may object on the amount of compensation, and if so, how do they do that?
For this, we need to refer to Section 37, Clause 1, Clause B, which definitely states that any person interested may raise an objection on the basis of the amount of compensation.
That is correct, Mr. Yutas. There is also Section 38, Subsection 2 states that grounds on which compensation is objected must be stated clearly in the form, and no other ground should be argued in the court.
Actually, there are several decided cases on this, sir. The first case is Triraman Bikasim B. Land against Land Administrator of Hulu Terengganu. In this case, the appellant's land was actually acquired to be used as a storage site by the government, and the appellant was highly dissatisfied by the compensation that was given because two parcels of land in the same place has been rejected to be used as comparisons to determine the market value of the land. So when he brought the matter to the court, the High Court had increased the amount of compensation from RM 4,800 per acre to RM 7,000.
That's really good, Mr. Risas. Good job. But actually, I would like to add, as we can refer to another case, which is Ng Tiao Hong against collector of land revenue Gombak, where the owners who were dissatisfied with the compensation being offered referred their dispute to the High Court. In the High Court, the judge apportioned the land into two different areas and assessed it differently.
So I guess we can conclude that we have established that dialogues may indeed object on the amount of compensation.
Yes, you are right,
Mr.
Mr.
Afiq, your mic was
Yeah. But continuing what I said just now, you are correct, Mr. Yutas, but we just have to determine the procedures of raising an objection on compensation.
okay. So about the procedure, it actually begins when the land administrator gives public notice under Form E of Section 10 and fixes a date of an inquiry for the hearing of claims of compensation.
You have forgotten to mention Section 11 also, in which it is stated that land administrator will also serve copies of notice to registered proprietor of.
Yes, you're right, Mr. Alif. Afiq. The next step, our client needs to make a deposit to the land administrator, which is around 3,000 or 10% of the amount we are claiming, as per Section 39(1) of the LAA. After that, the land administrator himself will refer the matter to the court within 6 months by using Form O.
Correct, Mr. Yutas, but and after that, the court will issue Form P under Section 43, which will notify the applicant, the land administrator, and all other interested person of the.
So after that, according to Section 40 Clause D, the amount should be the one decided by two assessors. If the amount of compensation differs between them, the judge will just choose whichever one he prefers.
Uh, Correct, Mr. Yutas, and we should also discuss in regards to Section 40D, subsection 3, which states that any decision taken by judge is final and no appeal to the higher court shall be made. And also Section 49, subsection 1 discusses further elaborations shall be no appeal made to higher court in a land reference case where dispute and decision of a high court regarding the amount of compensation.
So I think we have successfully established that Dialog Sendirian Berhad can indeed object on the basis of compensation, and they have to follow the correct procedures as we outlined.
We can move on to the next issue.
All right. So the last issue that we will discuss is whether Xylox is liable to the purchaser for selling the property, notwithstanding the acquisition.
Actually, sir, based on Section 8, Subsection 4 Land Acquisition Act, states that declaration under Subsection 1 shall lapse based on the expiry of 2 years and the date of the publication that relates to any land, in part of the land in respect of land administrator. All proceedings already, and also mentioned under Subsection 14, Subsection 1, the said period of 2 years accordingly, and the consequence of such declaration in respect of such land or such part of land shall terminate.
That is very correct, Mr. Afiq. For this, we can refer to the case of Straits Credit Sendirian Berhad against Pentadbir Tanah Daerah Wilayah Persekutuan Kuala Lumpur. In this case, the judge said that even though there is no provision in the LAA as to payment of any compensation, in the event a declaration for acquisition lapses, the consequence of a notice that has lapses pursuant to Section 8 Clause 4 should be the same as a withdrawal from acquisition pursuant to Section 35 Clause 2 of the LAA.
There's also the case of Lim Cheng Chuan Realty against Kerajaan Pulau Pinang, where it was held that 18 months delay from the date of formal will have the effect of affecting the landowner, who must not delay approaching the courts, or else courts would be asked not just to invalidate the acquisition. In a claim that the acquisition of land was in excess of what was required, it was held that the government was the proper authority for deciding what public purpose is, and must be presumed that the government in possession to declare the purpose of public purpose in general.
So from all these cases, we can see that the Form D that was published by the government had already lapsed and is now ceased to be in effect according to Section 8 Clause 4 of the LAA. So it will be regarded as withdrawal from the land acquisition from the state authority, and so the land will still remain with the registered proprietor and will not be transferred to the state authority.
I agree with the findings, sir. To put it simply, Zalok Sdn Bhd will not be liable for selling the property to the purchaser, as Form D had lapsed and it caused the land acquisition was ceased to be ineffective.
All right, so I think we have discussed all important matters pertaining to our client. In short, our client has to take two actions. The first one is to challenge the acquisition based on judicial review on failure to issue Form A, Form D, as well as Form K. The second one is Xylos can proceed with objection of the amount on compensation as per Section 37, Clause 1, Clause B of the LAA.
It seems like we have reached the end of the discussion. I will kindly ask the receptionist to set another date for the appointment with the client. Thank you very much for the discussion, Mr. Yutas. Have a good day.
Thank you very much, as well, Mr. Afiq.